Good morning, everyone. My name is Galen Scott, and I head the IP department at ENS. Welcome to our webinar on the intersection between fonts and IP and how typeface choice by organizations can have commercial consequences and pose legal risk. Allow me to introduce my colleagues who will be presenting today, both partners in ENS's IP team. Janine Thomas heads our commercial IP team and is one of only a handful of specialists in this field in South Africa. Dr. Bernard Dippenaar is a dual qualified patent and trademark attorney, and both are very knowledgeable on the topic of today's webinar. And the reason we decided to have this webinar is that several of our clients have received letters of demand relating to font use. Please, can I ask that any questions that you may have are put in the Q&A box, and we hope to be able to respond to them all at the end. If not, please send us an email and we'll respond to them then. We will be sending you a copy of the presentation, so no need to scribble everything down. And I hope you find our webinar of value. And over to you, Janine.
Thanks so much, Galen. I'm just going to kick off. Good afternoon, everyone, and a very warm welcome to everyone who's present. Thank you for taking the time to join us for the webinar. We're going to go through a number of aspects under the topic of fonts, but the idea really is to try and cover each component at a very high level, so that you walk away with some key takeouts in terms of what fonts are, the distinctions between typography versus fonts. We'll also then touch on how copyright becomes relevant. We'll cover briefly what some of the licensing models are in practice. We'll have a look at where the pitfalls happen, what some of the risks are with regards to unlicensed use. We'll also then touch very briefly on what we're seeing on the ground. What are some of the realities in terms of the claims that we're seeing? We'll give some pointers in terms of mitigation for your business. My colleague Bernard will then jump on to talk about protecting, a typography as a form of design or trademark protection. And we'll close out with some key takeouts for what you can do if you do receive a letter of demand that Galen just spoke about, and close out with some questions. So just moving on to what is a font. So before we delve into the technicalities of what a font is and what it really means, I thought that it would be useful for us to pause here and just talk about the value of fonts as a powerful brand asset. So fonts are not just about letters, they're not just about designs, but they really are a key component of how you build your brand and how you build distinctiveness in your brand. And if you talk to any designer or any creative, they will tell you that it is a key component, and if not as important as your logo. And the reason for that is because the font and fonts that are chosen very strategically by businesses to communicate certain brand messages. So, for example, if you saw the Coca-Cola brand in a completely different font, you would stop to ask yourself whether this is something that is original or whether Coca-Cola has embarked on a rebrand, but you will stop to ask questions. And that's because the font and the look and the feel of that logo is quite important to the overall branding and the brand message. If you look at the font that's used in Disney, for example, it's a lot more playful. It's there to communicate imagination, storytelling, whereas a brand like Vogue, on the other hand, uses a very clean and sophisticated font, which represents elegance and high fashion. And I have all of this on very good authority because I have a daughter who's a creative, and she loves fonts. So Netflix, for example, has developed their own font, which seems to be a stance that a lot of businesses are taking now. It also really just helps with brand consistency across the board. So really, fonts are, they are core to your brand, and they core to your overall brand recognition. ENS in the corner there as well also has a very distinctive font that they use, which again is very core to the brand messaging of the business. Now, turning to more of the technicalities of what a font is, I think that there's a misconception that a font and a typeface are the same thing. And we often use the language quite interchangeably, where we talk about a typeface or a font in the same sentence, but they are different. And the differences are quite key from a legal perspective. A typeface is really the artistic design or the style of the lettering. So it's the drawing and it's the visuals of how you design the letter. That's where all the intellectual creative thinking goes in. The font is the software that implements that design. So it's the software that allows that typeface to run. And then you get font families and styles. So this is anything from regular, bold, italics, and this is what you see on your screen and the options that you have available. So, like I said, typography really is the discipline of arranging texts. And when you are looking at typography, there's various factors that are taken into account, such as hierarchy, the style, the spacing of the lettering, the readability of that letter, as well as the layout, and also how the public will perceive or communicate or consume the content that's using that particular lettering. Fonts, on the other hand, are the software assets that are licensed for purposes of use. So these are executable font files, and you get different font files, OTF, TTF. They usually are subject to vendor end user license agreements. They are normally subject to per user restrictions, per device restrictions, depending on what licensing type it is. They are embedded in different platforms, and font software is treated as a computer program for intellectual property purposes. So if one is looking at examples, the distinction between typography and fonts on the one hand, you can think of a fashion designer and a tailor, where the fashion designer, will formulate the vision and the look and the feel of the garment, whereas the tailor will put it together, and that is what will be sold ultimately. So if you think of that, you can think of the typography as the fashion designer and the font as the tailor. And MP3s, yes, I think I'm showing my age here, but it's one of the most practical examples I could think of. But if you write the song and the lyrics and the notations, and then you create the MP3 file that ultimately plays the song, you would think of the song, the written song, as being the typography versus the MP3 file as being the font. So I mentioned that the distinction between typography on the one hand and fonts on the other hand is quite important from a legal perspective. And that is because font files are considered to be computer programs for the purposes of intellectual property, and specifically copyright. So computer programs are defined under the Copyright Act as being a set of instructions fixed or stored in any manner, and which, when used directly or indirectly in a computer, directs its operation to bring about a result. So it's very clear that the software, the source code that that runs this font file is a computer program and is protectable as a specific form of work under the Copyright Act. It would be subject to the same originality threshold as any other work of copyright. It requires a specific level of skill, labor, and effort, and not necessarily novelty, as you would think, for example, in the case of patents. The author is the person who exercises control over the making of the computer program, and that is as per the legislation. And the first author, first owner rule also applies. So generally, the first author of the work is the first owner, but this can also change subsequently. And the term of protection is 50 years from the end of the year in which the work is first made available to the public or is published. Now, the typical restricted acts, and when I say restricted acts, I mean that these are acts that are reserved for the owner of the copyright, would be your reproduction or any adaptation of the work, and any reproduction of a font file would be downloading it, sharing it, all of those would constitute reproductions. An adaptation of the font file would be, for example, converting the font file from one version to another so that it's adaptable on a different digital platform. These are all considered to be restricted acts and typically would trigger copyright infringement. Now, a typeface design, on the other hand, is generally not considered to be eligible for copyright, and that is because it's questionable as to whether there is sufficient skill, labor, and effort that goes into the creation of the mere letter form. So, for example, as it's displayed on the screen there, the question is whether converting the serif C to a sans serif is sufficient to say that there's copyright. So generally, it's accepted that this is not the position. And in some jurisdictions, such as the US, where, for example, you can register copyright, it's accepted that typeface is not protected by copyright laws. And I find this debate very interesting, because I had actually sat in a room with the typographer at some stage for a client who was developing their own font. And it was important for us to understand how he had come up with the particular typeface. And he took us through the end-to-end process of developing the typeface and the drawings and what goes into the drawings and why a certain part curls to the left or to the right. And I found it quite interesting because, taking the general approach that the drawing of the letters doesn't have any, there's no copyright in it. I think one would have to look at it on a case-by-case basis. But that really just stems from my conversation with the typographer and really understanding that there is quite a lot of work that goes into the initial drawings and the thought behind the shapes of the letters before the actual font file is then developed. And like I mentioned, by contrast, your font file is a computer program, so that is protected by copyright. There are other means that you can protect your typeface, and Bernard will touch on that later, but it could be protected, for example, by way of a design for the aesthetic features. So what are the common licensing models that you see for fonts out there? The usual ones are your desktop licenses, and these usually have per user, per device limitations. Then you get web font licenses. These normally have a page view cap. So if you're using them for your website, there's a cap on the number of views, and you'll pay per the number of views. And then more recently, with the development and the use of apps and ebooks, embedding into a mobile app, you also require a separate license for that. I wanted to touch briefly here on open font licenses, or what people refer to as free fonts. And I think that there's a general misconception that if you have a free font, it's free for use as you wish. That's not normally the case. In most instances, free fonts are generally for personal use, and they do require some form of attribution. So if you get a free font and then you start embedding it in all of your commercial documents and your advertisements, etc., that is not usually in compliance with the terms and conditions. So even free fonts have terms and conditions that need to be complied with. So one needs to be aware of that as well. Now, what are the common license pitfalls? So in practice, what we find is that um, it's usually not a case of organizations not having a license at all. So usually there is some form of license in place, but what generally happens is that the use of the software exceeds the license scope. So, for example, if you have a set number or a set number of purviews and you exceed that, so that's outside of your license scope. But then also, I think the other assumption is that if you have licenses such as your Microsoft licenses or your Adobe licenses, that those licenses which incorporate the use of certain fonts can be used across the board, and that's not necessarily the case. So another example would be embedding your fonts into mobile apps when your license doesn't necessarily cover that type of embedding and you need a separate license. Or, for example, if you are deploying the fonts in, in a app or a cloud environment, and that requires a specific type of license, there are some other types of pitfalls, such as, an employee going home, downloading a particular font file, and then bringing it into the organization and then using it for commercial purposes. That does happen. Another classic example is where you share your font files with your agencies who do your advertising, or with third parties or printers. Typically, the person that you are sharing that font file with, firstly, you shouldn't be sharing the font file, but if they are going to use the font file, they should actually have their own license to be able to run that software on their side. So we can't make the assumption that a download or that you have a license necessarily in place means that you're completely compliant. These need to be constantly checked to ensure that there is compliance with them. So, what are the risks of unlicensed use? I think the more practical one is what I would call license penalties, if we can call them that, where you have a foundry that approaches you and tells you that you've been using a font file or you've been using the software for X number of years without a license, and that you need to then pay these past license fees, and that you need to get a new license for future use. If there is ever a copyright action, and if it is ever successful, there are things like an interdict, damages, or a reasonable royalty, but there are also concerns around breaches of your contractual obligations in terms of your end user license agreements. There are some operational risks, such as takedowns. So I have encountered a situation where a font foundry had actually written to Apple asking Apple to take down an app on the basis that the font that was being used wasn't licensed. Obviously, Apple didn't act on it. They wanted a bit more, something in the form of like a court order. But it is something it is a strategic move that some of the font foundries are trying to use. If you have to change fonts, it might require rebranding. You might have disputes with your vendors or agencies, and obviously you might lose go-to-market opportunity. Reputational and financial, I'm yet to see a foundry calling out an organization for using fonts without a license. In most instances, they do try and settle and try to have an amicable relationship, because they do then try and foster an ongoing relationship with you after the settlement to try and get you to take out certain licenses. So it's not really in their best interest to go out and, but I think one must always keep these reputational risks at the back of your mind. And obviously then, settlement and legal fees associated with settling these disputes and paying these outstanding license fees are always an issue. So just in terms of case studies and what we're seeing on the ground, so I want to just start off by saying that we have not seen any font foundry actually institute copyright infringement proceedings for use of fonts without a license. As to whether they actually will institute proceedings, I think is questionable because there's a lot that rides on it. There's legal costs, there's time to go to court, and the time that the matter will be in court, and there's also going to be quite a big burden of proof on them in terms of establishing their rights, showing that there's infringements, etc. But the fact that there has been no legal action does not necessarily mean that the legal risk does not exist. So I think one needs to be aware of it so that when it does, come your way, you are properly prepared for it. Just in terms of some of the values of the claims that we've seen from these fund foundries and some of the settlements that have come about, because most organizations choose rather to settle and then remedy the unlicensed use for various reasons. It depends on your appetite for litigation and a number of other factors. But in the telecommunication space, for example, larger organizations, we've seen claims around 658,000 rand, which have been settled at around 150,000 US dollars. We've seen claims for over $1 million US dollars. In the smaller telecommunication space, we've settled for around 10,000 US dollars. In the financial services space, we've seen a settlement of 750,000 US dollars, and also smaller financial services, we've seen settlements of 60,000 pounds. So these are not insignificant amounts of money. And it is possible to, the fund foundry will come in obviously with a large claim based on their own licensing structures, but there's definitely room for negotiation. And as you can see from the first example, we've managed to negotiate that quite significantly lower than the claim that the foundry actually came in with. Now, some of the things or some of the pointers that we do raise in these negotiations and discussions is prescription. I think the first reaction that most people have is that you can't ask me 10 years later to pay a license for something that I started using 10 years ago. What about prescription? Prescription is a very valid point. However, when it comes to copyright, it becomes a bit more challenging because each new act of copyright infringement, each new reproduction, each new adaptation will restart an entirely new claim. So you can't then say that the claim is prescribed. And then there's also aspects of ongoing infringements. If you've never really stopped, then the question of prescription doesn't support your argument much. The other arguments that we've raised is around there's no copyright, like there's no copyright. But, perhaps, like I said, we can argue this from a typeface perspective, but it might be a little bit more difficult if it's actual font software that's being used. We look at possible coverage or protection under your existing Adobe or Creative Cloud licenses, where you might actually be able to use the fonts. We also push back on ownership. We find that a lot of the foundries actually represent the owner of the font, the party who actually created the fonts, and they just act as a representative. So it's always important to go deep and understand, do they actually own the font that they're claiming they own? Lack of knowledge, unfortunately, is not a defense to copyright infringements because most organizations actually just don't know. It can help with regards to claims for damages, but just generally, that's not a defense that can be raised. We also argue against using reasonable royalty considerations. Like I said, very often the claims will be based on what the foundry charges their licensees normally. And what you can then do is do sort of a comparative analysis and say, well, this is not a reasonable royalty because if you looked at what another foundry would charge for something similar, it's much lower. And then obviously obviously always looking at steps that you take to remedy the breach. When you are going into negotiations with these foundries, it's always good to have already taken some steps or shown that you are in the process of remedying, the unauthorized use before, trying to settle the matter. So, what are some of the points that, what some of the mitigating points or some of the things, the proactive steps that one can take to try and mitigate these risks? So, a font audit or a font register is always the best. I mean, it's an ideal situation. It's always a bit more difficult, especially in larger organizations, but knowing what you are using and just having that knowledge is really key to mitigating these risks. Having your appropriate licensing in place. In other words, making sure that the license that you have is suitable for the needs of the organization. So not having a web license when you actually need a license for apps and you need a license for desktop, and limiting your license and then finding that you are outside of the scope of your license. And procuring those licenses through the correct procurement processes, because then it's easy to track and go back to your procurement team and say, oh, did we procure this? How much did we pay? How long is the license, etc. Most organizations are standardizing fonts across the board. It also just helps, just in terms of everybody knowing what they can and can't use. Making sure your contract clauses with your agencies and your producers are intact, making sure that whatever third parties are producing for you using particular fonts, that they have the necessary licenses and you have the necessary licenses, so that you don't find yourself in this type of situation. Training your staff and having governance tools such as your policies and your playbooks, which are easy access documents that allow your employees to be able to tap into this information, have it readily available in terms of the do's and don'ts. Your IT controls are obviously critical in terms of what you're allowed to download and what you're not. And I left point 4 for the last because it is going to tie into what Bernard's going to talk about. But creating your own font is definitely an option. Most organizations, like I said, are adopting this route, and just then finding means to then protect it. And at this point, I'm just going to hand over to Bernard to take this particular point further. Bernard, over to you.
Thanks so much, Janine. So yeah, I'll be touching a bit on designs and trademark protection. So this is something you need to be aware of, either if you want to protect your own font, and also the registered rights that might be owned by third parties that have also created their own fonts. So just briefly on what is a design. So a design is a type of registered right to protect the shape, the pattern, configuration, and ornamentation as it is applied to any article, and where those features related to those aspects are to be judged solely by the eye. Now, there's a lot of legalese, but basically it just means the ornamental features or the aesthetic features that can be applied to some article or medium. And it is judged by the eye. It's something that jumps out to you. So if you were to consider a typeface, it will be that very unique illustration of how those letters and numbers are actually illustrated or typed out or written in that particular typeface. Okay. Now, design is very powerful in the sense that it allows you to exclude third parties in the country where the design is filed from making, importing, using, or disposing of any article that embodies that design. Okay. Now, if we apply a typeface, it will then be when they apply that typeface to any goods or even a medium, such as a website or a piece of paper or marketing material. Now, below is just some more typical examples of designs. On the left-hand side, you'll see a shoe. You'll either think it's the prettiest or the ugliest shoe in the world, but it is these Crocs. And you'll see that the way it has been constructed, it has very noticeable aesthetic features. It's got that sash, that little circular item there where the Croc logo will be. And then it's got this unique arrangement of the different holes and also those ventilation holes. So they have filed quite a few designs over the years as these shoes have changed to protect these aesthetic features of their products. And in the middle, we've got one of the very first designs ever filed for Coke. I think it's in the 1930s. And before this, they had those bottles that looked like medicine bottles with the stoppers. And what actually resulted in these new bottle shapes for Coke is they had a competition in the 1920s, and a company called the Root Glass Company, they actually won that competition, and it led to these very unique curved bottles that Coke has been using and reimagining over the years. But they filed designs for each iteration, and the power or the strength of that design is you don't even need to see the Coke logo on these bottles. You know their aesthetic features are for a Coke bottle. And in the right, you've got an Apple Watch. And what they've covered here actually is just this rectangular or square face where that little dial is placed, and then also the one button. You'll see little dotted lines for the sash or the strap. And that's just because it can use different straps. So they have purposefully only focused on the screen. Now, you might also ask, why would you file a design? You've got copyright and perhaps trademarks and all these different forms of intellectual property. And they do all have their role to play. But for a design, it is actually very powerful in the sense that once you file a design application and it becomes registered, it will become registered as a form of intellectual property registered in your name. And you are, the starting block is that you've got registered rights in your name. If you were to go along copyright, perhaps, sometimes in court, you first need to prove who created the work, who's the owner, and then only you arrive at the test of determining if there was infringement. Copyright infringement. In a design matter, the court is generally only tasked to look at if there was design infringement. So it is a much faster route to get the relief that you seek, but they all have their role to play. Okay, just the next slide, please, Janine. Right, so here's an example of an actual design that has been filed for a typeface. So you'll see there's indicated on the left figure 1, and then I just retracted the actual name of this typeface. But how you will file these design applications is you now need to show these ornamental features or these aesthetic features. So you will show each and every type of character, letter, or number in each of these figures. And you'll see here they've been arranged according to the lowercase letters, the uppercase letters, numbers, and then all of these different characters, which might also include then, not might, it does include all of the letters with these different accent marks, like in German, the umlaut, and all of the different accents that are used in different languages. And this will then cover almost all of the characters that can be used on a keyboard. So now you cover the illustration of this typeface with this first figure. Just then moving on to the next slide, please. What you will actually do in these types of design applications is that you will have different figures for the different ways in which these typefaces can be illustrated. Because you will have seen on your Word, you've got different versions, so to say, of the Arial font. You'll have or Calibri or whatever the case might be. It might say Calibri Light, it might say Calibri Bold or Calibri Heading. They're all different variations, but as Janine said, they've got very unique curvatures, and those are associated with this particular typeface. So in this one design application, you can cover all of those different versions, so to say. And here you just see in figure 1, this now covers the bold version of this typeface. And figure 1, for example, will then be for where all these characters and letters are in the italic expression of that font. So what we also do is you will need to focus on the different jurisdictions where you operate or where you even plan to operate, because design applications are very time sensitive. Once you file the first design application, you then typically have 6 months before you need to decide in which countries you want to also file further designs. And it is quite a well-known practice to protect typefaces in the different countries or jurisdictions. But there are some African and Asian countries where it is basically still being decided. Some applications have been filed, but the Patent and Design Office in those countries are currently grappling with whether they want typefaces to be protectable by designs under their laws, because the moment that they do confirm that they can be, it will open the floodgates, so to say. But a lot of the major jurisdictions, this has been going on for, in some cases, more than 100 years. So just going on to the next slide, please, Janine. So this is such an interesting example I found while I was doing research on typefaces, when they started and how they came about. So the first ever design application in the United States was actually filed for a typeface. And you can't see exactly what is shown there in that letter, so to say. This is actually the design application. But if you've ever read some of these old legal documents, they always start with such a humorous way. They'll say, for example, be it known that I, George Bruce, I have invented certain new and useful improvements in the use of fuels. Or now, therefore, I do declare the nature of my invention is to cure some kind of disease like shingles. So this one is obviously very old. I think it's 1842. So this letter starts with George Bruce, the creator of this first typeface covered by a design, saying, "To all persons to whom these presents shall come." I'm not sure what the presents refer to. I'm guessing the unique characters that are in this little letter or design application. But what then follows is George then writes out all of the different characters and numbers that he wants to be protected for this particular font. So since this first design application, a lot of design applications have been filed across the world to protect different typefaces. It is definitely an underutilized resource to protect your typeface. But I think in recent years, typefaces have become a bit of a hot topic, so to say. And where companies now create their own typeface, it really is important to protect it with a design, because as I mentioned earlier, it's quite a quick route to enforcing your rights as opposed to other forms of intellectual property. And then it differs a bit in different jurisdictions or countries, but a design is typically for 15 years. It protects it for 15 years. Just the next slide, please, Janine. So that then covers designs and design applications. Something that's also very important to just consider is trademarks. And they work hand in hand with copyright and designs. So trademarks will be to actually cover the name of your font. And what's very important is, if you do create a font and you call it something, it mustn't be confusingly similar to an existing font's name, because that might constitute trademark infringement. And I just went to the South Africa Register for Trademarks, and I found the different trademarks that have been filed by one of the largest, if not the largest, font foundry in the world, called Monotype. And here you can see in this table the different trademarks they have filed for different fonts in South Africa only. And this is not an exhaustive list, but some of them will sound familiar. You've got Times, you've got Helvetica, I hope I'm saying them right, and then you've got Arial, and they just cover their own company name as well. And then you'll see there in the column that indicates class, they filed in class 9, which is for software. And you can imagine it's because these fonts are being used on different websites. And then class 16 then is for paper and stationery. And that will be perhaps where it's being used in a published book or whatever the case might be. And parties will refer to the fonts being used as Times, Helvetica, or Arial. So if you do create a font and you want to give it a name, be very careful of what you're going to call it. And just because you are now going to call it Arial and you spell it with an E instead of an A, please be aware that just if it sounds the same, it can still be trademark infringement. So try and come up with a completely different name for your font. And if you're going to put on materials that you are using your font with name X, it should not be confusingly similar to existing fonts. Just the next slide, please. And a lot of you might be very familiar with Monotype, and you might have crossed paths with them or had some business dealings with them. They have global reach. This company has filed 845 trademarks across the world. They have started filing these applications since 1924, so they have been around for a very long time. 302 of those filings were in the United States, 192 in Great Britain, and 152 in Europe. And they actually have a tab on their website where they list all of these hundreds of trademarks that they have filed across the world. So if you want to go double check if your font doesn't have a similar name to one of theirs, they've nicely categorized it already according to the different letters as well, just to do a double check, and just be mindful of that. And it is quite interesting how Monotype has actually shifted their business model. They actually used to be a printing company or publishing company where they filed several patents for how to use different metal materials to print on published materials like paper or books or whatever the case might be. And then they completely shifted in the late 1900s to becoming a digital publishing company. And they are now one of the leading typography companies in the world. And what they are doing is they are designing new fonts, they are licensing their existing fonts, and they are also then managing the software and the fonts as part of their business model. And they have, if I'm not mistaken, they are also the exclusive font business partner of Microsoft. And that's the reason why you see all of those fonts that were in that table being used in a lot of the Microsoft products. So they are definitely one of the leaders in this space. Thank you, Janine. I'm then going to hand over to you for the last slide.
Thanks so much, Bernard. Very interesting there with the old design. So really just some key takeouts. The very basis or the core business of a font foundry is to license their fonts to third parties. That is how they generate revenue. And it's unlikely that, they're going to sit back and allow that business model to be eroded by unauthorized use of fonts, particularly by, large corporates. So I think it's important to understand that it may reach your organization, if you are a larger organization, probably sooner rather than later. And it seems like they are going down a list and that they are then approaching each of these respective organizations to deal with past use and future licensing. So be wary of it. Just understand that font files are computer programs. They are protected under copyright law. Like I mentioned earlier, in some jurisdictions, these copyright is actually registrable. So they might also, in jurisdictions such as the US, also have registered copyright. So the rights do exist. And, because it's questionable as to whether a typeface design is protectable, you would want to, if you are looking to getting your own font. You would want to stack your rights. You'd have copyright in the code, but also then protecting the registered design and the trademarks, like Bernard had mentioned. Most of these disputes with the font foundries are settled by way of doing audits and settling, not by way of litigation. But I think that, don't ignore these font foundries when they do come to you in the hope that they're going to go away. Decide strategically how you are going to address them, whether you are going to dispute the claim, or whether you are going to, simply state that you are not liable, or whether you're actually going to settle it, or whether you're actually going to have the appetite to wait until they institute proceedings and then defend it. But one thing they certainly will do is they will continuously write to the most senior person in your organization, and it will become frustrating for you, particularly if you are the legal person who is looking after claims of this nature. They will write to your CEO, they will write to your chief marketing officer, and ultimately your businesses will look to you for answers. So I think it is important to get your legal teams involved. And when you do find these matters on your desk, and you are required to negotiate these settlements, you can negotiate hard. You don't necessarily have to pay what they are asking for. There is scope to negotiate down. I find very often that when the first approach is made to, for example, your marketing team or your business team, there is pressure that is put on them to make payments of these exorbitant amounts. But I encourage you to get your legal teams involved, because it is a legal issue. It is a copyright issue, and it must be addressed through the lens of copyright laws. When you are negotiating, bear in mind that you want to get the strongest and most protective warranties and indemnities for your organization, to make sure that these claims don't come back to you 10 years from now. And then governance is always, like I said earlier, very critical, to be more proactive rather than dealing with these claims on a reactive basis. And just then ensuring that any contractual terms that you have with third parties, that you keep fonts in mind, and that they are dealt with in the way that you would deal with any other form of valuable IP in your organization, making sure that you have the right warranties and indemnities as well. So this brings us to the end of our presentation. Like Galen said at the beginning, we will share the presentation. So you are welcome, if you have any questions, to email both Bernard and I, if you don't want to ask the questions now. But I think we are going to, Bernard, are you able to access the Q&A? Oh, I see these. Okay, I see that there's 2 questions in the Q&A. There's 3 answered. Bernard's already answered them, guys. Like, Bernard is on top of this. Thank you,
Those are
Bernard.
just technical questions.
Okay, no, perfect. But if there are no other questions,
So
I
Janine,
think
these first 2 are unanswered, the ones that are
okay, so
currently
the
referred
first
to.
2 are unanswered. Okay. Perfect. So could a typeface not be an artistic work and protected by copyright? Yes, that is the case. So I mentioned earlier that I had actually spent quite a bit of time with a typographer, and I got to understand fully the level of skill that goes into it and work that goes into it. And one must remember that the test for copyright subsistence is whether sufficient skill, labor, and effort have been put into the creation of the work. And while it's generally accepted in other jurisdictions that you can't claim a monopoly into the look and feel of the letter, I do think that it would have to be assessed on a case-by-case basis, and that potentially, if it were to go to court, this is something that could be put forward, because there certainly is a lot of creative effort that goes into the typeface component and the creation of that typeface before you go into the font stage. So yes, I do agree with that. The second question, as the agency, we have Adobe licenses. Is my client covered under this license for the artwork supplied? Generally not. Usually your licenses are for you, and it also depends on the type of license. So if you get a license for your business, it's usually a license to enable your business to operate, but not for you to pass it on to your clients. So generally the answer is no. So yeah, just double check your licenses, but that's usually not the case. The third question, if monotype do not institute litigation, why settle? This is a very popular question. You can certainly take the stance that you are not going to settle and that you are not going to entertain the request. But I think the important thing that you just need to bear in mind is that there is a possibility and there is a risk that they could institute those legal proceedings, and whether you have the appetite to wait it out. From what I have seen from most organizations, it's primarily one, risk appetite, but also I think large organizations don't really want this type of claim hanging over their heads, for it to be sitting there for the next 2 years and then suddenly you are in court, and you find yourself having to spend all the time, the money, etc., trying to defend this. And also I would say that if you know that you are using the font, and you are using unlicensed software, to wait to get sued, you might potentially find yourself in a worse of position than you are now. So you certainly don't have to settle. And you can certainly choose to adopt the approach of not entertaining them, but you also need to weigh it up against what your organization's risk appetite is for dealing with potential litigation down the line. I hope that answers everyone's questions. Bernard, you wanted to add something?
Yeah, just adding to that last point, it is a very interesting question. Yeah, so just for everyone to be aware, some of these demands come in waves. So if you might not have received one of these demands and you are actually using some of these fonts, don't think that these font foundries are not watching or won't reach you at a later stage, because they actually have monitoring software that is able to extract usage on public facing materials. So that would include apps on Android, iOS, and even websites. And even your company's website, it is quite simple to actually go and see that the OTF files are being used. So it is easy to scrape that website to find that it is being used. So just be aware that they have these tools, and don't ignore the fact that you might need to do an audit just to see that what type of fonts are currently being used and whether you do have the requisite licenses for those. So it does really require attention, I think, now rather than later. Thanks, Janine. I see there's
No
two more
problem.
questions.
There's one more question, I think. Do you have case studies of companies in South Africa that have settled? So the examples that I gave you are South African companies. It's just that the claims were made in US dollars, and that's because the Font Foundry is a US-based company, and in the other instance, it was a UK-based company. I'll just have to double check. But the companies that the claims were made against were South African-based companies who we've supported. I don't see any other
I think just scroll
questions.
down, Janine. There's one from
JD. Oh, there we go, Jadine. Hi, Jadine. To what extent should organizations treat font as an IP risk rather than a design choice? I definitely think that it should be treated as an IP risk. it's a design choice. Yes, it is a design choice, but it's a design choice that ultimately does have implications from an IP perspective. So I would certainly say that you definitely keep it on your radar as an IP risk. We certainly look at it in that light. So, for example, if we were doing a due diligence or some other form of investigation, we certainly ask the question around fonts in the context of unlicensed or licensed copyright works. So certainly, yes, I would treat it as an IP risk. Who would do an audit? So I told Bernard that this question would come up. So Bernard is au fait with companies who do audits of this nature. So I'm going to ask Bernard to just chat around the types of audits, and I imagine that it would be the similar type of software that, for example, a monotype would have, and that's how they're able to then establish that you are making license use. Bernard?
Yeah, there's some nice tools out there that can actually identify different fonts being used, and they simply scan a back-end database to see what a font might be on a picture or whatever the case might be. So an audit will be a bit of a collaborative effort where we would use those tools, investigate the different materials. It is going to be a bit of a case-by-case basis, but it will start with a few questions from our side, and then we deal with different aspects of the business to see how fonts are being used and whether you might be working with third parties that result in fonts being used in different aspects of the business. So it is something that we do and we've done a few times. So there are tools available out there, and it'll be a bit of a step-by-step process.
Thanks, Bernard. The next question is, if business is correctly licensed for where a typeface is used, does the creative agency they work with need to be licensed to produce the work? So the creative agency's license is a license for them to be able to produce the work, and the business itself should have its own license to be able to use the work. So it's never a shared type of license. And my answer to that would be that the creative agency needs to have a license to be able to utilize the work to do and produce the services that they produce for the organization. And what I've seen is that agencies actually sometimes procure those licenses on behalf of their clients to ensure that there is compliance. So the answer is yes, you would need your own separate license. I'm just going to quickly take, there's two questions. I'm going to try and run through them very quickly. We have 1 minute left. So the question is around filing the typeface as a trademark. So the rules around, or the principles around trademarks would have to apply, and you'd have to assess each one on its own merit. So the question would be whether the letter with the curve, for example, whether it performs the function of a trademark, i.e., is it capable of distinguishing another C from the C of someone else who is using it in relation to the goods and services? So it is a question that you would have to apply for each and every instance. Certainly you can register trademarks there are letters that are registered in specific form, but you can never get a monopoly in the letter in and of itself, but it would be the specific form of that letter. And certainly what you'd have to show is that if the public sees that letter, they can identify it with your goods and services rather than just being a normal letter. So that would be that. And then, are fonts not IP assets as opposed to IP risk? I think you can't really separate the two. If you are going to call something an IP asset, you need to appreciate the risks that are associated with that. If you have a trademark or a patent, that would be an IP asset. And with that IP asset would come associated risks. So, for example, if someone owns a trademark and you are using their trademark without authority, that is an IP asset, and the associated risk would be that you would potentially be sued for trademark infringements, and that is an IP risk. So I'm not sure that we can quite draw a distinction between the two. They are associated, but yeah, that would be my response. I see that we've run out of time. So I'm going to stop there, and just thank everybody for taking the time. Thank you for your very involved questions. It's been very good to see your thoughts around this. If there are any specific questions that we haven't answered and that you'd really like us to answer, please do reach out to us and we will gladly assist. Thank you so
Thanks, everyone.
much. Thanks, everyone. Cheers. Bye.